Good morning, everyone. If you are like me, you've noticed that everything these days is an argument. And if there is any public entity that I think embodies argument in the public mind, it's the U.S. Supreme Court. So imagine, as a non-attorney, my astonishment when, I think it's 3 weeks ago now, that, 3 weeks ago, there was a case where the Supreme Court was unanimous in ruling on something. And that's what got my attention, because ordinarily, as a non-attorney, I don't read Supreme Court cases. But 9-0 got my attention. I figured, what in the world can a divided Supreme Court possibly be unanimous in agreement about? And the answer was real estate, as it happens. And my name is Andy Norton. I am a realtor with Sampson Properties in Tyson's Corner. And our guest this morning is real estate attorney Rob Bodine, Esquire, with Cardinal Title Group. And at the conclusion of this video, when it gets uploaded onto YouTube, Rob's email address will be there for you to see so that you can contact Rob having to do with real estate related subjects. So in any case, how is it that, I'm going to do a little bit of background and then you do the rest of it. How is it that a 94-year-old grandmother that's living in a senior center in Minneapolis finds her place in history in this particular case? What's going on here?
Well, Geraldine Tyler, Geraldine Tyler owned a condominium, and she was having trouble living on her own. So they put her in assisted living. And when that happened, and she voluntarily went, she wasn't forced. And when that happened, the property started to be neglected. Tax bills weren't being paid, homeowners insurance dues weren't being paid. I don't know if this is the case, but I'm gonna guess that the mortgage bill wasn't being paid. But the mortgage company isn't who foreclosed.
That's right.
The county of Hennepin in Minnesota, which covers Minneapolis, they foreclosed. They had a tax sale and sold off her property to pay that tax debt. So that's how it happened. Interestingly enough, she owed $15,000 on the tax bill.
Right.
Okay. The property was sold at $40,000. Now, for the purposes of this video, we're going to assume that that's fair market value, because the Supreme Court applies something called judicial restraint. They don't hold any more than they have to, and they address the issues brought to them.
Correct.
And the $40,000 number is what was brought to them. So we're going to assume that $40,000 was the fair market value of the house, even though it probably wasn't. Yes. And the mortgage bill at the time was $49,000, which could be because she was late, but also could be because she had, $20,000, $30,000 in equity. Who knows? But we're going to assume it's $40,000. So they sold it for $40,000, and as a result, the state made a profit of $25,000, or let's say there was an excess.
There was an excess.
Because the state didn't actually make a profit, it still cost them money to enforce, et cetera, et cetera.
Right.
But they had an excess of $25,000, and the state, or the county, but the state generally speaking, kept the $25,000.
Right, and as I understand it, doing my homework on this, it's not just Minnesota that did this. There are, I think, 11 other states that engaged in this practice. And in my homework, evidently it is called home equity theft. So
I don't think that's a legal term, but it certainly is a fair description of what we're talking about.
Yeah.
And it doesn't sound good, and there's your explanation as to how this was a unanimous decision.
Okay. So evidently there was an organization called the Pacific Legal Foundation that wrote, by all accounts, am I pronouncing it right, an amicus brief?
Amicus brief.
An amicus brief, a friend of the court brief that evidently the court found so compelling that even though it was a friend of the court brief, It was evidently very well done.
Right. So just for explanation, the friend of the court brief is a third party. So you have your plaintiff, you have your defendant, maybe you have multiple plaintiffs and defendants, but I could write an amicus brief in that case as someone with some sort of a concern. Okay, but I'm a third party. I'm neither the plaintiff or the defendant. I could still do it. That's what an amicus brief is, and they have a concern. They represent clients that this case, the decision in this case would affect.
Yeah, and evidently this particular case struck a lot of people as being particularly egregious. You know, a good one to take to the Supreme Court on the whole issue of taking a property. So, correct me if I'm wrong, is it the Fifth Amendment of the Constitution where there's a takings clause?
The takings clause, yes.
Yeah, okay. And so, there's another case that preceded this. And when we were chatting off camera, was it Timms? Timms versus Indiana. So Timms is not quite on point, but I think it illustrates a trend. So discussing Timms sort of builds a case for predicting where the Supreme Court goes from here. So in Timms versus Indiana, Timms was convicted of conspiracy to commit theft and dealing in heroin. The maximum fine under Indiana law combined for all his charges was $10,000. Okay.
But he used his $42,000 Range Rover in that commission of the crimes.
Right.
So the state initiated a civil procedure called civil asset forfeiture to take that Land Rover, and then they could sell it off and use that money to pay for the prosecution. Right. The problem is that Land Rover was worth $32,000 more than the total punishment he could receive financially
on the
for
drug
all
case.
of those crimes, on the drug and theft case.
That's right.
So the Supreme Court, and this is going to become a theme, referencing Magna Carta.
Yes.
Going back to June 15th, 1215.
That's right. Almost an anniversary, the 808th anniversary of the Magna Carta.
Going back to the Magna Carta says, hey, look, for all this time, 808 years, 804 years at that point. This is
at that point.
2019. Yeah. Over 800 years, the law has recognized that is an unlawful taking, that you have to give back the excess.
Correct.
Okay, so the 10,000 is fine. I think that's what you were just thinking there. The 10,000 is fine.
That's right.
But the 32,000 is not.
That's right.
And Timms lost this case all the way up to the U.S. Supreme Court.
Yeah. Well, Geraldine Tyler lost her case all the way up to the Supreme Court.
The state courts got it completely wrong.
Yeah.
So in that case, in Timms, the court held that the excessive fines clause of the Fifth Amendment was violated. Okay. So, but here's the operative point here, that the court was concerned with the financial taking, even from a criminal.
Yes.
Okay, because it's still a taking. It's still a legal taking.
That's right.
A criminal cannot be punished excessively, nor can they be fined excessively. So then that leads us, that's sort of a precursor, but that was a unanimous decision. That was Ginsburg and Scalia together again, joining forces to protect the little guy.
Yeah, well, in this case, though, you have Justices Gorsuch and Jackson joining forces.
In the concurrence.
In the concurrence, which in a sense, I'm not an attorney, I didn't stay in a Holiday Inn Express last night, but I was surprised to see two justices of such radically different perspectives.
Yes.
Joining in a concurrence.
Yes.
Okay.
But let me tell you something about the Supreme Court that I think surprises a lot of people and shouldn't. The philosophical disagreement in the court is judicial, not political. But those judicial philosophies do tend to favor one party or the other.
Okay.
So people will support one philosophy versus the other. But they kind of blur that distinction. Here's a test for you. You go to like scotusblog.com and that lists all of the Supreme Court decisions. Just randomly pick a year and randomly pick a number between 1 and 30 and then go to that number down the line of the case. And if you just start reading the cases, you will see 9-0, 8-0 if someone recused themselves, 9-0, 8-0, 71, 7-2, 8-1. You'll see these majorities all the time. And the only time, not the only time, but in terms of the general trend, the only time you see a political split is when the case is something like same-sex marriage, abortion, etc. It's only when you get to political issues that the court kind of goes crazy. But on most of these cases, they're kind of easy. And you see a lot more unanimous decisions than you might think. This happens to be an intersection of a really, really easy case that is politically charged.
Okay.
And therefore, it's out in the public, and yet neither political party supports the state in this case. So it's an easy, very easy case despite being political.
Okay, fair enough. In this case, Tyler versus Hennepin, which is the condominium one we're speaking about, and also Tim's, which was the seizure of the Land Rover that we're talking about. In both of those, you have lower courts that have ruled against, and the Supreme Court takes the case and reverses the lower court.
Correct.
Is it considered a rebuke of the judges in the lower court? If in the case of Tyler, the district court and the Court of Appeals both said essentially, non-legalese, I'm sorry, ma'am, you messed up, okay? And then it goes to the Supreme Court and they accept it and rule unanimously to reverse the lower court. Is that considered within the system a rebuke of the justices and their legal ruling on the lower court?
Not necessarily, because you can imagine two scenarios where it wouldn't be fair to call it a rebuke. First, that prior case law of the Supreme Court demanded that decision.
Okay.
And so now the Supreme Court is revisiting that decision and saying, you know what, we don't like what we did, so we're going to rebuke ourselves. But the lower courts had to follow that for all these years. That's one possibility.
Okay.
The other possibility is that it's a case of first impression. It's something that's never been decided, and the courts are trying to figure it out at the lower level. Some courts go one way, some courts go the other. That's called a circuit split. And then the Supreme Court resolves that split by finally dealing with the decision.
Okay.
But in this case, it's a rebuke. And it is made obvious by Gorsuch's language in his concurrence. Because if you notice, he says so in this case, really quickly, there were two issues, the takings clause and the excessive fines clause.
Yep.
And the takings clause, which we'll go over in a second, was decided in Tyler's favor. But again, remember that judicial restraint I mentioned earlier?
Yep.
The Supreme Court decides only what they have to. So the Supreme Court said, well, since she wins completely under the takings clause, she feels she's gotten adequately compensated. We're not even going to address the excessive fines clause that was relevant in Tim's, right? Mm-hmm. Well, Gorsuch came back and said, well, maybe you should have. Because, and Kajani Jackson Brown joined that concurrence, said, you should have, because the district court got it horribly wrong, and the appellate court referred to the district court decision as well-reasoned.
Yes.
So that means that the next time a case comes up dealing with excessive fines, but not necessarily dealing with takings, those clauses, the lower courts are probably going to get it wrong. So they really should have done an analysis and said this is clearly an excessive fine, basically because this is clearly, at least in part, a punitive measure, a punishment-related measure. It's not merely remedial, fixing something, the tax bill. but it's actually punitive because there are fines and costs and things like that.
Yeah.
So in this case, at least the concurrence was certainly a rebuke. Maybe you could argue that the majority rebuked them as well, but because of judicial restraint, just didn't do it so aggressively. But certainly the concurrence was rebuking the lower court.
Okay. So one of the things that I wanted to ask you about, because to a certain extent, okay, I sell houses, and prior to it becoming final, it goes to cardinal title, and as an attorney, you do the closing. And there's a buyer there making a set of assumptions that, in a sense, go back to the Constitution, that the government cannot take their property without due process and just compensation. And I mean, isn't that sort of like the foundation of what we've come to call, quote unquote, the American dream? Because in other countries, you cannot do this.
Sure. And this really goes back to, at the risk of offending any of our British immigrants, this goes back to how offensive so much of the behavior of the kings were to our founders. And so for example, and this is relevant to this case, the concept of eminent domain states that the government can take for public use private property. Mm-hmm. That's inherent to the power of government. And the founders recognized that, they just didn't like it. And so what they did was they added, and there's support for this in British law, but it wasn't always followed historically. There were periods where it wasn't followed very well. They said, well, we need a takings clause in our Constitution that says you can do these things. You can throw people in jail. You can take their money. You can take their property. But there better be due process, or if it's purely civil, well, not necessarily purely civil, but if it's civil or if it's purely financial, you better provide just compensation. You better reimburse them for it, a fair market value, which itself has led to lots of litigation we can't go over here. That's a dispute, but yes.
Yeah. I guess what I'm getting at, though, is that home buyer by home buyer, down through the years, there's a set of assumptions which we take for granted. Every single home buyer takes for granted that it's their home, and that there's a set of laws and precedent that not only is it theirs, and if they pay their mortgage and they pay their taxes, it cannot be taken from them, but also, and going back to the Magna Carta, when they die, it can be left to whomever they designate.
Yes, sure.
Okay. As I understand it, in a lot of other places on this planet, that's not the case. You really have to have a basis in British law for that to be the case.
Let's refer to it as Western law.
Western law. Okay.
Because, France, I wouldn't say is British law.
Fair enough.
As you can see down in Louisiana, where they practice Napoleonic law.
Correct.
But it's all Western law, and it's the same basic concepts that spring from the minds of the same Western philosophers. So that's the tradition that we enjoy here in America. But we can consider all of Europe a test run. And when we got to America, we said, you know what, let's look at the past, let's look at how this hasn't followed through well, and let's build in some even more protections. And let's actually mean them.
So, as I understand it, you were sort of following this Tyler case and the precedent or none that it may have, depending on the voting, for cardinal title. Is that right?
No, not for cardinal title.
Oh, you were
not on behalf of cardinal title, on behalf of me.
On behalf of you, okay.
Yes. So in 2004, I had been an attorney for 3 years, and I was just, give or take a month, I was just starting real estate closing, so I wasn't really a real estate attorney. But in any case, 2004, my grandmother dies. And it's just, her home is not even on my radar scope. So my uncle, my dad has already predeceased her. He died in 98. So I inherited 1/12 interest in that house and didn't know it and just didn't even think about it.
Because it was 1/12 of an interest.
whether it's 1/100th of an interest or 100%, I just didn't know.
Okay.
It just wasn't on my radar scope. I didn't think that way.
Fair enough.
And I should have. But in any case, my uncle, he's paying the tax bill, et cetera, et cetera. So 2017 comes along and he stops paying the tax bill. And the tax bill goes to $5,500. They sell it at auction. They sell it at tax sale. They have a tax sale. So
Not unlike what's going on in Tyler.
Correct. But even more egregious, because Tyler lost $25,000. This property is worth at least $170,000, and I think it might be worth $220,000, $230,000. Mm-hmm. Her tax bill was $15,000. Our tax bill was $5,500. So, and again, I'm not even thinking about this. My siblings aren't thinking about this, and it all just sort of, it happens in 2017, and it isn't until a couple months ago, in May, right around the time that Tyler was being argued, that I get served as a defendant in this case. And so I'm like, I don't know. I don't know what this is worth. It's not worth my trouble, right? But my cousin calls me up and she says, can you please do something? So I did file a brief. But in any case, it's kind of the same thing, but even more egregious.
And what state was it in?
Pennsylvania.
And is Pennsylvania one of the, what I'll call the dirty dozen states
yes,
that got reversed?
Yes. But here's the difference. Here's the question. Here's the difference between my case and Tyler's case, which means if I were to pursue this, and if this were to go to the Supreme Court, which I think would actually take this case, or the next one that's like it.
Yeah.
The question in this case is, what would have happened in Tyler if instead of selling it for $40,000 and keeping $25,000, they said, well, if we can't have this money, nobody can, and they just sold it for $15,000. They would still be taking a property worth $40,000 or more.
Correct. That's right.
So isn't that really the proper taking? And what's interesting is in Tyler, they referenced a case, Lawton, US v. Lawton, where they, instead of selling the property, the United States government just simply kept the property. Mm-hmm. And the way I read Lawton, and the way I think the Supreme Court now would read Lawton, is the moment you take that case, you take that property, that is a taking. And there has already been, to use tax law terminology, an ascension to wealth for the government. They've already taken that money, mm-hmm. that value. And therefore, at that point, you are owed the difference between fair market value and what your debt was. Okay. They don't have to sell it for that to happen.
One of the things that jumped out to me, again as a non-attorney, actually reading the opinions and actually listening to some of the argument last night too, is that the justices from the Supreme Court referred to the Minnesota taxing collection regulations as a quote-unquote scheme. So does the use of the word scheme already indicate that they're moving in a general direction towards an opinion?
The Supreme Court, that is?
The Supreme Court. Is the word scheme a pejorative to describe what Minnesota is doing with respect to this, to Geraldine Tyler?
I don't know, because a lot of times legalese is not as harsh, is not as meant as harshly as it sounds. I think there's enough in this case, and certainly enough in an oral argument, which I think you've listened to.
Yes.
There is enough in the oral argument, the questioning, the harsh questioning, and then this unanimous decision that took 29 days to issue after argument, which is
not much.
Really fast. I mean,
yes.
they heard this case, they blasted Hennepin County, and then they said, you know what, let's just write this and get this done because these guys are idiots. There's enough there that you could maybe infer that they meant to use scheme in a harsh way. Yeah. Not necessarily, but maybe. But either way, this was a harsh decision. This is admonishing those 11 states, and no question.
So it's not just admonishing the judges who ruled against Geraldine Tyler before it got to the U.S. Supreme Court. It's admonishing Hennepin County.
Hennepin County at all those counties and all those states
And
that
that's
do
right.
this.
That do. Okay. Because our illustrious videographer and host at the Northern Virginia Association of Realtors has given us a 5-minute warning. Let me ask everyone in the audience who has found this discussion fascinating and would like to see more, be sure that you hit the subscribe button on YouTube, click the like thumbs up, and be sure to leave a comment in the section below. As I recall, you had a quote on there that you wanted to, that you thought would be particularly enlightening, that you wanted to share with the audience?
Yeah, but I pretty much covered it without the quote. So
Okay. So basically, I think that transaction by transaction, the people that we see before us who are becoming homeowners, are oblivious to the fact that they are, in a sense, heirs to a tradition of legislation and legal philosophy that goes back not only to the founding of our country, but to many centuries prior to that. Is that fair?
yeah, I think that's
Okay.
fair. Yeah.
Okay. Yeah, I wanted you to say yes, because otherwise that would be a rebuke of the host.
I'm not going to rebuke you.
Rob Bodine, Esquire, Cardinal Title Group, thank you very much for appearing this morning and sharing your insights on both Tyler v. Hennepin County and also in Timms v. Indiana, and hopefully the appropriate counties and states, those 12 states, which were doing the conduct that the Supreme Court rebuked in Tyler, are busy changing those regulations as we speak. Thanks very much, everybody. See you
Thank you.
next video.